Hello, welcome to today's webinar on protective orders. My name is Jessica Houghtby. I am an attorney with Pennington Law, and I'm here to talk to you a little bit about protective orders. Before we get started, I want to read a disclaimer to you all. I am an attorney, and Texas Legal is a nonprofit legal benefit plan. Texas Legal provides members access to over 400 network attorneys and offers various insurance plan options. Contact information for Texas Legal will be in the comments in the description box of this webinar. Nothing in this video should be taken or relied upon as legal advice. The topics discussed herein are for general information purposes only. You are encouraged to seek independent legal advice regarding your specific facts and circumstances. I also want to let you know that some of the subject matter material we'll be discussing today is really sensitive and possibly confidential or privileged. And so please be mindful of what you're posting in the comments, because if you post too many or any facts about your particular case, then that could destroy confidentiality and does destroy attorney-client privilege. I am not giving any legal advice today, but I am going to be discussing some legal topics. So with that, let's get started. My name is Jessica. I have been licensed since November of 2012. I primarily practice in the field of family law, which is divorces, child custody, litigation, and under the family law, under the family code, protective orders. I do some misdemeanor criminal cases, and I do some simple will drafting, powers of attorney, things like that. And so protective orders are in my area of practice. So let's get started. Today, we're going to be talking about three common types of protective orders, and really three protective orders that I deal with in particular. And those protective orders are going to be under the criminal code as stalking protective orders. Also under the criminal code, magistrate protective orders, and under the family code, civil domestic violence protective orders. We are going to go into so much more detail. I'm just kind of giving an overview. So I will answer some of your questions as we go. There are other types of protective orders that we probably won't get into as much detail today, including human trafficking protective orders. You can get protective orders for documents. Sometimes people talk about protective orders for documents so those documents can't be released. And then also sexual assault protective orders. So if you have any questions about those kind of protective orders, you're going to really want to consult with your own private attorney. But some of the information that I give today may help guide you toward what type of attorney you're needing to talk to. We're also going to go over the application process, hearings, what protective order hearings are like, what judges are looking for, and oftentimes a pretty confused topic of protective orders versus temporary restraining orders. And finally, we're going to talk about a domestic violence finding, which can really impact somebody's life. October is Domestic Violence Awareness Month, and so this is a really good topic to be talking about right now. And we're going to somewhat talk about both sides of a protective order. We're going to talk a little bit about what happens if a protective order has been served on you, or a petition for a protective order, application for a protective order has been served on you, and you're being somewhat accused of domestic violence. And then we're also going to talk about how to get protection for yourself, primarily about how to get protection for yourself in a couple of different situations. First of all, I keep using the word protective order, and I'm not sure that everybody knows what a protective order is. A protective order is a document signed by the court that protects an applicant from a defendant's particular behaviors. Typically, in the types of protective orders we're talking about today, that behavior is threatening, abuse, harassment, things of that nature. But your protective orders can also outline other things like if there are children involved, a possession access schedule, child support, whether or not somebody needs to go to therapy or batter's intervention program. All of those things can be handled at a protective order hearing and ordered by a court at a protective order hearing. So the next, the first major topic I wanted to discuss is Stalking protective orders. I see those have become a lot more prevalent in my practice. And a stalking protective order is a protective order to protect somebody from being stalked. And the way that a stalking order or stalking protective order is ordered is that the applicant has to prove that there are reasonable grounds um, to assume that the applicant is a victim of stalking. Now, that can either happen through a hearing where evidence is presented, or that can happen if somebody is convicted of a felony stalking charge. And there's a presumption that it qualifies as reasonable grounds. And so what that means, and I'm going to kind of try to back off a little bit some of the legal speak, but I think when it comes to stalking, a lot of people have a particular perspective of what stalking is, and you kind of have this classic idea that somebody is driving by your house, right, or looking in your windows. Of course, all those things are stalking. But stalking nowadays has become a lot more technological as well. So stalking protective orders protect people, or stalking in the criminal violation basically involves, and this is not the technical definition that can be looked up in Texas Penal Code, in the Texas Penal Code, but basically involve more than one occasion where somebody is harassing you or harassing an applicant that puts an applicant in a reasonable fear of bodily injury, death, offenses, major offenses against their property, or causes them to be harassed, annoyed, alarmed, abused, tormented, embarrassed, those kinds of things. And that is the criminal charge of stalking. So if somebody is arrested for stalking um, and is ultimately convicted of stalking, then typically that the county attorney will request a stalking protective order, and that protective order can be put in place up to for the lifetime of the applicant or the defendant. And so the way that it becomes prevalent in my practice is that you use the same definition of stalking to get a protective order to prohibit um, civil parties from stalking one another, and those two can be protective orders that are put in place for a lifetime of the applicant or the defendant. The applicant protective order is just a person requesting the protective order, and so I think I've started to see those more in family law cases, typically in divorces, child custody cases, where people are texting each other, calling each other, um, saying nasty things to each other, not even just calling each other, but calling the teacher at school and saying, my ex is this, that, the other. My husband is doing X, Y, and Z. My wife is doing X, Y, and Z, in order to harass them or torment or embarrass that person. So, and again, comes in a multitude of ways. It used to be this classic idea that you would drive by somebody's house and then you take a picture of a car driving by your house, and that was stalking. That most certainly is stalking and petrifying. But it really is. I put up these photographs because it's a bit more of a multimedia format. And so a lot of the ways that we're seeing that present itself is through phone calls, text messages, emails, kind of just communications to third parties that aren't a part of the case, but is intended to be threatening or embarrassing. Okay. And so if you do find yourself in either a criminal situation where you're being stalked, or a family law situation, you need to bring that up with either an attorney or the county attorney or district attorney, who can give you some better advice about whether or not your particular circumstances rise to the level of needing a protective order for stalking. Also, just so you're aware, stalking is a third-degree felony for first-time offenders and can be enhanced if there's a person with a serial stalking, um, for serial stalkers. One other thing that I want to know is that stalking, the criminal charge of stalking, um, is there is no relationship requirement. So a lot of times people think of ex-husband, ex-wife, husband, wife, boyfriend, girlfriend, that those are the only people you can get protective orders against for stalking, and that's not true. It can be anybody. The next protective order that I want to talk about is the magistrate's emergency protective order. So what this is when somebody is arrested for assault family violence and taken to jail. Before they're released, they are typically served with or given an emergency protective order prohibiting them from going around, communicating with, threatening the alleged victim of the assault family violence crime. And those protective orders will often tell that person, restrict that person from going. So, say it was with a husband and a wife or partners that live together, live in partners, will restrict that person from going into the home. And so they effectively constitute what we call a kick out order. These protective orders are typically in effect for between 30 and 60 days. And then the county attorney, the district attorney may request a permanent protective order depending on the circumstances, or the alleged victim may hire a private attorney to request a civil protective order that could be permanent. So just because there's a magistrate's protective order in effect doesn't mean that any other request for protective order should be disregarded or should not be requested, because those emergency protective orders are only in effect for a finite amount of time. They have to be in effect for, I believe, at least 31 days, and they expire after 60 days. So there's not going to be a magistrate's protective order in effect for longer than 60 days. And so if protection is needed after that, you really need to go and contact either county attorney, district attorney, or a private attorney to help you apply for that. Civil protective orders are where my primary area of practice is when it comes to the protective order topic. Civil protective orders are protective orders that are that can be permanent protective orders that are put in place in domestic violence situations where either the party hasn't been arrested for domestic violence, or an applicant has requested private attorney's help to get a protective order, a permanent protective order. And I say permanent. Protective orders are typically only in effect for up to for 2 years, unless the severity of the allegations would warrant a protective order being put in place for longer, or it's a stalking protective order, which are stalking, human trafficking, sexual assault protective orders are usually in effect for a lifetime. And so, who can file? If you are a victim of domestic violence, or your children are a victim of domestic violence, you can file for yourself. You can file for your children. The county attorney, the district attorney can also file for you or your children. And so, so who can file for you? Your parents can file for you as well, if you're underage. Oftentimes, people who apply for protective orders request protection for any household members as well, which is permissible. And so the next step, so once you file, the typical way that you go about filing is you either contact a private attorney or the county attorney or district attorney, and they will take down information, request all the instances that you can think of past family violence. That will be put into an affidavit, which is then signed by you. I'm talking to you, assuming that you're requesting a protective order. This is kind of the universal you. Just because you're watching this doesn't mean you're looking for a protective order. But the applicant will be signed by the applicant, testified to by the applicant through notarization, and then filed. A lot of times, if somebody does not have an emergency protective order from the magistrate, because either there was no arrest made or for some reason that protective order wasn't put into place, then the civil court can consider applications for protective orders, emergency protective orders, on what we call an ex parte basis, and that's just saying that the attorney or the party, the applicant, approaches the judge without notifying the other side to try to get an emergency protective order put in place. A civil emergency protective order is only good for 20 days. We call them ex parte protective orders. A civil ex parte emergency protective order is only good for 20 days. That can be extended on either on the court's order one time for 20 more days, but within that either 20 or 40-day period, a hearing needs to happen. And that hearing, so the way for your civil emergency protective order, what the court's going to be looking for is there's a clear and present danger that domestic violence is happening in the household, or it is happening in the household. And that's what that affidavit needs to show, is that there is domestic violence occurring in the house. Now, once within that 20-day period or 40-day period, if there's an extension, there needs to be what we call an evidentiary hearing. An evidentiary hearing is kind of what you would imagine a hearing looks like, something that you see on TV. Parties go to court, have witnesses, evidence, possibly attorneys. Don't have to have attorneys, but you can have attorneys, and a judge, and there's testimony that happens. Somebody sits in the witness booth and questions are asked and answered, get the opportunity to cross-examine, etc. And so what happens, how do you prepare for one of these hearings? Well, to get your 2-year protective order, or, longer, depending on the severity of the severity of the allegations, you have to show, or the applicant has to show, that that family violence has happened in the past and is likely to continue to happen in the future. And that's the evidence. That's what the applicant thinks about whenever they're gathering their evidence. So what kind of evidence would you think you would need for showing that family violence has happened in the past? Evidence that's useful for this can be anything from testimony, either the applicant's testimony, even the defendant's testimony, witness testimony. If somebody saw family violence happen, that person can be called as a witness to testify about that. Photographs. If something happened and somebody has a black eye or a scratch or a bloody nose, taking photographs, if you're going to need a protective order, is going to be helpful. Oftentimes, and you can also get testimony about family violence happening in the past. You would assume that the defendant isn't just going to show up and say, yeah, I was abusive. And so there are other types of evidence, or other types of evidence that I use. For example, there may be text messages between the parties about the incident. And even if it's not an outright confession that, yes, I was abusive, I'm sorry I was abusive, or I'm not sorry that I was abusive, then maybe if it would lend some credibility to the situation, if you were maybe, or if the applicant and the defendant were still maybe arguing about a particular situation, and the applicant testifies, yes, we were arguing about that situation, and that's what led to the domestic violence. And so those. Oh, and also police reports. And I would encourage you, if you were ever a victim of domestic violence, and I know it can be very difficult because oftentimes domestic violence happens between you and somebody that you care about, somebody that you love. But I would encourage you to call the police, because the police are going to be able to get you the highest level of safety, the highest level of protection, and then and then also that evidence can be used for civil protective orders for you to continue to try to protect yourself. And so police reports can be used as evidence that domestic violence happened in the past. And police officer testimony, if a police officer shows up to the house on a domestic violence call, then obviously they're going to have some testimony that, yes, this person looked in the way that they're saying that they looked, and that the defendant admitted or didn't admit to something occurring, to being violent. Now, the one that's a little more tricky is whether family violence is going to continue happening in the future. So evidence that I will look for as to whether or not family violence is going to continue to happen in the future is um, a lot of the same types of evidence, right? You may have testimony from the applicant saying, yes, as he was leaving the house, he threatened me that he was going to come back and hurt me. Or as she was leaving the house, she said, if I called the police on her, that she's going to kill me. Things like that. Those types of statements can be used as evidence that family violence is going to continue happening in the future. Other evidence can be, threats by text message. Um, Sometimes we'll use repeated incidences of family violence, as evidence or likelihood that family violence may continue to happen in the future. And maybe you have a situation where there's been violence and the applicant testifies, yes, he or she said that she was never going to hurt me again. And then here we are, they hurt me again. That can, maybe be some evidence that family violence is going to continue to happen in the future. There's a lot of different ways and a lot of creative ways to look at evidence to determine whether or not, or to use that evidence to determine whether or not family violence is going to continue to happen in the future. Say that party is ordered to stay a certain distance away in an emergency protective order and they continue to violate that. Or they move in an apartment down the street, or something that keeps them close, and that there's cause for concern that they are going to continue to be abusive. That's all evidence. Threats, testimony, continued domestic violence even after the police are called, all evidence that domestic violence may continue to happen in the future. Um, and so on that topic, I will say that is the most difficult part of a protective order hearing. And to get your long-term protective order, you have to show that domestic violence is likely to continue to happen in the future. And that is the most difficult part to show. And so ways that defendants oftentimes come in and try to show that that's not going to happen or that the applicant doesn't believe that's going to happen, is maybe the applicant continues to let the defendant come around them, come to the house, go to places where the defendant regularly goes, things like that. Another time I find I've seen, heard about, read situations, participated situations where maybe the defendant moves like to a completely different state. It's very unlikely that if a defendant lives and you live in Texas, or applicant lives in Texas, defendant lives in Maine, that it's good that family violence is going to continue to happen. So the court has to determine at that point whether or not they think that family violence is going to continue to happen in the future. And so those are some pitfalls, and I would say defensive strategies, because we defend people who have been served with applications for protective orders as well. And so those are the kinds of things that we look for with our clients, as far as whether or not that prong is met at the hearing, where you ultimately will either get awarded a protective order or not, ordered a protective order or not. So in the context of divorces and custody cases, we often get requests for protective orders when really parties are asking for a restraining order. And it is somewhat of a nuanced difference, because restraining orders can be used in regard to domestic violence. But temporary restraining orders are really very broad. A temporary restraining order is meant to when there's an irreparable harm that is immediately present. And that can be anything from, in a divorce situation, maybe one party is about to liquidate a bank account, to, one party was seen yesterday driving drunk with the kids. And so temporary restraining orders have a lot more remedies. I would say there are a lot more options for remedies. For example, temporary restraining orders can restrict a party's possession or access of kids. It can limit a party's ability to access bank accounts. It can restrict a party from selling property. It can restrict a party from drinking while in the presence of their kids or using drugs in the presence of their kids. And so and a temporary restraining order is only in effect for 14 days until this evidentiary hearing needs to happen. And so at the evidentiary hearing, you'll usually get what we call temporary orders, which are, for lack of a better way of saying it, Texas's version of separation. In Texas, we don't have separation agreements. And so there either has to be a divorce or a custody case filed, and temporary orders will be put in place to protect the safety and welfare of the parties, and to preserve any property that the parties own while they're going through the divorce process. Kind of sets the ground rules for the divorce or custody process. Now, protective orders can be filed in conjunction with divorces or custody cases. Typically in conjunction with divorces. Custody cases are a little bit different. But if the kids are being abused, then protective orders can be, and certainly are, filed in conjunction with custody cases. But for divorce cases, if there's family violence that's happened, outside of the divorce case, a protective order case can also be filed. And in a situation where there's significant family violence or any kind of domestic violence, there often are protective orders filed in conjunction with divorce cases. And those are kind of handled somewhat hand in hand, although they are separate cases, completely separate cases, and don't have to be handled at the same time. Temporary restraining orders also can be used when there is family violence, but they don't have the same effect. A temporary restraining order, if it's violated, or even temporary injunctions, if they're violated, the remedy, the way that it's enforced, is through what we call contempt, which is typically a civil remedy. Whereas if a protective order is violated or an emergency protective order is violated, the enforcement is through arrest. It's a criminal. There's criminal penalties, and repeated violation of a protective order can result in increased criminal liability. And so the protective order has pretty strong teeth when it comes to enforcement, and so it is fairly reserved to these situations where there is a danger present. And finally, I want to talk a little bit about domestic violence finding. Contained in a protective order is typically a domestic violence finding, because the court finds that domestic violence has happened in the past and is likely to continue to happen in the future. And so there's typically what we call a domestic violence finding. And what this means is this has other effects other than it's just labeling somebody as somebody who has committed domestic violence. So some of those effects are people who have a domestic violence finding against them can't have guns, may not be able to have guns. Oftentimes some of these are contained in the actual protective order, and may not be able to get a hunting or fishing license. Domestic violence findings do have effects in child custody cases. There are certain presumptions that parents with domestic violence findings have to rebut in order to get certain types of custody. And so if there's a domestic violence finding, it certainly does affect your a custody case. And also a domestic violence finding sometimes allows a landlord to remove a tenant from a lease if they're a victim of domestic violence. And it allows them to break the lease and leave the offender on the lease so that they can get out of the lease and get protection. Domestic violence findings also may affect somebody's ability to foster or adopt children, and it can affect immigration status. And so that's pretty much what I have planned today to talk about. Protective orders are very useful in getting the kind of protection that you may need from a domestic violence situation. And really, I just want to tell you, so many times I have clients come to me who have been in domestic violence situations where they they need help and they need protection, and they haven't been able to get that protection. And so I would just really encourage you to talk to an attorney. The other resource, and I know I kept alluding to it, but there is a very valuable resource in the county attorney, and the district attorney, in that they have access, I would say easier access to police records, and things like that. And so I would encourage you to talk to either a private attorney or the county attorney and district attorney, if you find yourself in a domestic violence situation that you need protection, because these types of situations can very quickly escalate. And so I hope that gave you all some information that will be useful to you, and that you can use to protect yourself. And I don't see any other questions in the comments. And so good luck and be well. Thank you.